My name is Maggie Coffin-Krause, and I am an instructor here at the university, teaching environmental law each year. This year, I had the privilege of working with the Environmental Law Society here at the law school. And one of the initiatives that the Environmental Law Society wanted to do was a research project that was very relevant to our province and to current issues in environmental law. And so it's with great pleasure that I got to work with these amazing students. And what you're going to hear today is a research project, the culmination of their research project amidst all their studies, which was, they all had full course loads. I'm going to do a little introduction on each person who's going to present today. And we would respectfully ask that if we could have the questions towards the end, then the whole panel can answer any questions you might have. And plus you might find that a question you have may come up in a presentation that's in one of the other persons coming through. So just by way of context, none of the students own property in the province, none of the students are currently employed with the government, and none of the students currently are employed by any exploration organization. So it's truly an unbiased group. And what they did, and Kathy's going to start us off shortly, what they did was they did a true analysis of what the laws are here, what they are like in other jurisdictions, what worked, what didn't, and did a comparison through it all. And I think you'll find that their findings are very reasonable and very, very intelligent. We are kind of on the fly this morning in the sense that we don't have the key to the console. So the presentation is going to be verbal, and anyone who is interested in getting a copy of, I think it's in PowerPoint, yeah, it's in PowerPoint with lovely pictures. It's a very nice PowerPoint presentation. Please, we're going to pass around a piece of paper. Just jot down your email, and we'd be happy to send it around. And also by way of context, the students have presented this paper once before to the Canadian Bar Association in St. John back in February. It was a closed group and very well received feedback. So this is their first public forum, if you will. So on that note, I'm going to introduce them individually. First, you're going to hear from Kathy Lewis. As of yesterday, I believe she finished her second year, correct? Here at the University of New Brunswick. She is a co-chair of the Environmental Law Society and the Outlaw Society, and does leadership training for CISV International. She recently joined the board of directors for the Youth in Transition House, and she spent last summer at a law firm here in Fredericton and plans to continue again this summer. Before attending this law school, she achieved her Bachelor of Arts in Political Science and Contemporary Studies at Dalhousie University. And then next fall, well this fall, she's off to Denmark to study Immigration and International Law before completing her final semester at UNB. So you'll hear from Kathy, first she's my second on my left. After Kathy, you're going to hear from Rebecca, who is third from my left. And, pardon me, Rebecca is, well, she was a third year law student when I read this the first time, so officially she's probably graduated here at the University of New Brunswick. And last summer, she traveled to Rwanda for a 2-week genocide education program, and then spent the remainder of the summer working with the Rwandan Ministry of Justice. She's currently the co-chair of the Environmental Law Society, and before attending our law school, she completed her Bachelor of Arts and Bachelor of Education degrees from Memorial University in Newfoundland. And she will also be articling here in New Brunswick. And going to lunch with me from time to time, because she's going to be in St. John. After Rebecca, you're going to hear from John. And John is also just finished his studies here at UNB, and along with Rebecca and Kathy, a co-chair of the Environmental Law Society. Heavily involved in linking pro bono students Canada at the university with local environmental organizations. John also works as a summer student with a local firm here in Fredericton. And before attending law school, he received his Bachelor of Science degree with a major in biology. And he will, and I'm so excited, be doing his Master's in Law, Environmental Policy and Sustainable Development at Queen's. It's still Queen's, or you can in your choice. he said his choice of universities. Queen's University in Belfast in the fall. So that will be John. And last but certainly not least is Mr. Solomon on the far left. Wayne is a JD MBA grad candidate at the UNB and founder and president of Tundra Consulting, a consulting firm in relation to accounting, information technology, and project and contract management in the Nunavut territory. He currently serves on the board of the Nunavut Business Credit Corporation and served on a variety of other boards in that region. He formerly a CFO for, and I'm going to pronounce this wrong, Kitnuna. Okay, well, there you go. Kitnuna Corporation and the Fort Nelson First Nation. He's a certified management accountant, associate chartered management accountant in the UK, and an accredited director. He has his Bachelor of Business Administration degree and is currently completing his Master's of Science in International Construction Management. So that is our esteemed panel today. So on that note, let's start off with Kathy, who's going to launch us into this project.
Hi, thanks for being patient with us and our starting exercise outside with an appreciation of the weather. Apparently before it snows. John keeps saying it's going to snow tomorrow. I really hope not. But thank you all so much for coming out on a Saturday to discuss this important topic. As Maggie mentioned, my name is Kathy Lewis. So we don't have the benefit of our PowerPoint, but I'm going to do my best to try and explain sort of some of the more visual things that wouldn't be displayed. So shale gas exploration, as it seems right now, is imminent in New Brunswick. And our purpose today is to discuss the technical aspects and legal implications of the shale gas industry. It's essential that this process be examined prior to development in New Brunswick and exploration. So we're going to be considering 4 separate jurisdictions in this presentation: New Brunswick, Nova Scotia, Alberta, and Pennsylvania. Nova Scotia for proximity reasons, Alberta because of the developed oil and gas industry and because it's Canadian, and Pennsylvania because Pennsylvania represents the starting point for shale gas exploration in North America, which sort of has similar bedrock formations to where we are in New Brunswick. So we do acknowledge that there are other jurisdictions that are currently exploring shale gas, such as Alabama, Ohio, and Texas, but we are going to focus on these 4. So with the current state of the world market, it's unrealistic to assume complete dependence on renewable sources of energy. We have to continue to pursue new oil and gas reserves, but there's difficulties that come with this pursuit that need to be managed. Shale gas drilling has led to environmental degradation, but has also been shown to occur with very few ill effects. As for New Brunswick, these cases need to be examined and regulations put in place to ensure that our resources, our property, and our people are protected. Shale gas drilling is one of the more newly discovered sources of fossil fuels in North America, and its drilling process and technology is still developing. And shale gas, as it's currently being drilled, seems to be endlessly abundant. We keep discovering more and more sources of it. It has the potential to be produced cheaply, easily, and close to major markets. As such, there's a big rush to drill for shale gas in North America. Despite this rush, the province of Quebec and the state of Maine have both introduced moratoriums on shale gas exploration, and this is mainly due to concerns over the environmental impacts. Unlike our neighbors, New Brunswick has appeared to expedite the exploration process in order to gain a market advantage where Quebec and Maine have their moratoriums. This expedited process, however, may result in much more complex and serious legal issues as a result of a less carefully regulated approach to exploration and extraction. So fracking, or hydraulic fracturing, I'm sure you guys coming to this are already well educated on the subject, but it's a process that's used to extract natural gas from shale beds thousands of feet below the surface. And as with any drilling process, inherent with it are environmental concerns. So I'll kind of explain as it is. A vertical well is going to start the process, followed by horizontal drilling into the shale bed. And this is the newer form, where it used to be simply just vertical wells. Now it's vertical wells followed by horizontal wells. And this is to maximize the surface area over which the gas is collected. I don't know why I'm doing this.
Where's your chalkboard? Okay.
Oh, okay. All right. So this is the ground. And then you have, your well tower, what have you, and you drill into here. And then this This is the shale here. And now shale, because of its fine grain size, it's impermeable. So natural gas is either absorbed into the organic matter in the shale or becomes trapped in porous silt. So here. So what we do is we fire a bunch of water and chemicals down into here and here so that little fissures happen. And it's through these fissures that the gas can flow through this pipeline and back up to the surface, if that makes any sense. So injecting water, sand, and chemicals into the borehole at high pressure is going to create those fissures. The sand keeps the fissures open while the water's going through, and the chemicals serve various other purposes. So a lot of what people are talking about is the chemical additives. The chemical additives count for about 0.1% of the fracking fluid that's sent down into the borehole. And this typically includes a biocide, corrosion inhibitor, citric acid, friction reducer, and scale inhibitor. Tens of thousands of cubic meters of water, typically withdrawn from local water sources, can be used in a single well. The water used is then contaminated with the chemicals and has to be disposed of safely or treated before it can be re-released into the groundwater. So groundwater contamination is probably the biggest concern with fracking, given the confining nature of the shale beds. Their impermeability and the sort of thickness of the rock here makes them ideal places for aquifers. So aquifers are just big old pockets of water in the earth through which most of New Brunswickers get their well water from. So hopefully a well wouldn't be right here, but if you have a well, it's going to be going into the aquifers, which are down below. And the concern with this is that it's going to contaminate those aquifers, which are then going to contaminate the groundwater. So aquifers used for drinking purposes, all sorts of purposes for rural New Brunswickers. But one big thing is that they're quite a bit closer to the surface than the actual shale bed is. So it wouldn't actually be this far down. It would be sort of here, whereas the places we're drilling would be weird drilling. The places that development companies would be drilling would be much further down. And we're talking thousands of feet. It's a terrible scale. It's an awful scale. So because so many New Brunswickers rely on these wells as their main water source, contamination on a large scale would be catastrophic. Any spills of the fracking fluid after it returns to the surface, or a failure to properly store, treat, and dispose of the water could result in enormous costs to the province and its people. However, the process of shale gas exploration and extraction doesn't happen overnight. Between identification of the source and commercial development, heavy testing and geological surveying occurs. So shale is found in most sedimentary basins across Canada. The Canadian Society for Unconventional Resources identifies 5 stages in shale gas exploration. First, the resource is identified. This stage involves acquiring the land, acquiring seismic testing and drilling permits, and conducting the initial geophysical and geochemical surveys to determine if there is sufficient resource potential to go ahead with a capital investment. Second is the early evaluation drilling. This stage involves conducting initial seismic surveys to map any gas-bearing formations and find any geological formations that may affect drilling, initial vertical drilling, and the collection of cores. So what I would have now is it's a picture of New Brunswick, and you can kind of see sort of where the different fault lines are. And there's a lot of concerns right now over earthquakes and seismic testing causing earthquakes. And if correct sort of geophysical, if the geological engineers are hired and are doing their job properly, they'll be able to see we can't drill here because the rocks are just going to collapse. And there has been quite a bit of drilling done where engineers and geologists are able to look and properly examine where they need to be drilling. So then comes pilot project drilling. And this stage involves drilling the horizontal wells to further define any sort of gas properties. And these involve conducting initial production tests, drilling further vertical wells in other areas with gas potential, and fracking other test wells to get an idea of the productivity potential. Finally comes commercial development. So this stage involves making a commercial decision to proceed or not, and obtaining government approval for construction of gas plants, pipelines, and drilling. So that's the final big stage. So natural gas in New Brunswick is found in unit deposits from the late Devonian to the late Carboniferous periods, and this corresponds to different levels in the ground and different densities of rock, as far as I understand. Covering northeastern to southeastern New Brunswick, extending somewhat through the center of the province and into the southwest. So more on the eastern side of the province than it is on the western side of the province. 9 companies currently hold a Crown license to search and lease land in New Brunswick, and these include 71 rights agreements for the exploration and production of oil and gas in New Brunswick. The majority of oil and gas exploration is currently only in the surveying stage, but 2 fields are producing oil. This is the Stony Creek oil field outside of Moncton and the McCully gas field outside of Sussex. So multiple legal issues are going to emerge at every stage of the shale gas extraction process. This includes the seismic testing, drilling well sites, impacts on property values and existing livelihoods, accessing water to frack the wells, and the management of this flowback water that comes back up to the surface. Beyond mere regulatory infractions that are going to occur during the development process, environmental impacts are typically going to emerge much later and are going to be a lot more difficult and costly to mitigate. As such, one of the main impediments to shale gas development is the public concern over these environmental risks. These concerns have been understood by many to stand in direct contrast to any sort of shale gas development. So the environmental impacts and risks are often lumped all together in one sum and not clearly distinguished from one another, and as a result, heavy emotional and political arguments begin to culminate. Environmentalists are pitted in the media against the developers, and the issue is unnecessarily polarized. It becomes sensationalized in a way. Opponents to shale gas development in New Brunswick feel as though they're not being listened to by the government. As a result, their opposition to the government and developers becomes much more aggressive, and the neutral public education about the issue, such as we're trying to do here, becomes more difficult. But a lot of the concerns that are being advanced by these environmental advocates is shared with the provincial government and the developers. When broken down, these environmental impacts are comprised of personal, corporate, and governmental interests. One of the main concerns with potential environmental degradation is the impact on property that's in close proximity to the well sites. The jeopardizing of property rights, which is a right so fundamental to the Canadian common law, has to be fully considered as a threat. The possibility that an outside source could impact the value of land ownership in our province comes with the prospect of serious legal battles down the road. Regulatory frameworks are in place to properly assess and dispel these risks before development is allowed to continue, but concerns have been raised in New Brunswick about the sufficiency of these regulations and if they're even being properly upheld. The authority to enforce regulatory provisions is dispersed amongst different regulatory bodies and government departments, as my colleague Rebecca Butler will discuss. The regulations are intended to ensure that developers follow standard geophysical, drilling, development, and production practices. There's also legislative and approval requirements to be met. The New Brunswick Department of Environment has introduced a phased environmental impact assessment process. And the goal of this process, as listed, is to identify potential environmental impacts at the early stages before a project is implemented so that negative environmental impacts can be avoided or reduced to an acceptable level. This process is supposed to begin prior to well pad construction and include the well pad location, so where it's going to be in New Brunswick. Public involvement and stakeholder engagement also commences at this stage. This new phase process has yet to be implemented, so isn't currently happening, but it's not clearly understood by everyone in the extraction process. And we feel that this is not an ideal state of affairs for having these new regulations followed. Public consultation is not an optional aspect of the development process, and in order to clearly understand what this acceptable level is, we have to effectively understand who holds a stake in the development process and consult accordingly. An acceptable level is not an objective standard to be imposed upon various communities without consultation. Rather, it's subjective and context dependent. This is our province, and we share the resources, the air, the water, and the desire for prosperity for future generations. The regulatory body framework for shale gas extraction in New Brunswick is currently only in the development stage, despite the apparent imminent nature of extraction in the province. and we feel that these two can't transpire at the same time. The novel nature of shale gas means that we don't have full evidence of what can result from the extraction process. If we wish to avoid an uncertain future with uncertain costs to our natural resources, we have to develop a regulatory framework to acceptable levels and ensure that they're implemented before our first well is even fracked. So now I'm going to yield the floor to my colleague Rebecca Butler, who's going to speak to current provincial, federal, and municipal jurisdiction on the issue.
Good afternoon. As Kathy just said, I'm going to look at shale gas regulation at the provincial, federal, and municipal levels. And I'm also going to discuss how shale gas activity affects Aboriginal issues. So I'll begin with the provincial jurisdiction. The New Brunswick provincial government has a firm hold over the regulation of the natural resource industry by virtue of Section 92A1 of the Constitution. Provinces have the power to approve shale gas operations within their jurisdiction and also have the power to pass a moratorium on the operations, such as the Quebec government has done. Under provincial regulations, there are many steps that must be taken before drilling begins. First of all, a prospecting license needs to be acquired, and this is according to Part 4 of the New Brunswick Mining Act. The holder of this license can enter and travel upon the land using the tools necessary to prospect. And it's the holder of the license who will be liable for any damages or interferences for the use and enjoyment of the property. A prospecting license does not give the holder exclusive rights to drill and expropriate the resource. Before the drilling lease is granted, the potential developer and holder of the license must stake their claim. And there are two methods for staking a claim in New Brunswick. First one is ground staking, which is a physical staking of the claim. And secondly, you can map stake, which is an electronic method of staking. The New Brunswick government will then grant a license to drill a well. This is pursuant to Section 8 of the New Brunswick Oil and Natural Gas Act. If drilling on Crown land, the developer is required to get a lease. If you drill on private land, you need permission from the landowner to access the surface rights. The Crown has reserved the rights to any oil or gas that is extracted, so therefore if you have property, if anyone has property rights to land, those property rights do not extend to the oil and gas that's extracted from the land. This process of prospecting, staking, and leasing leasing the land can turn a routine real property transaction into a complicated matter. Prospectors may stake claims that cross privately owned land, and there is no requirement to notify the landowners before staking begins. Notification is done as soon as possible after the claim has been staked, but landowners must give consent before exploration begins. However, if there's no agreement reached between the developer and the landowner within 2 months, the developer is able to post a security bond and proceed with development. Any disputes that are between the developer and the landowner are often settled by the mining commissioner. According to Section 37 of the Oil and Natural Gas Act, the province has the right to restrict the amount of oil and natural gas that may be produced within the province. So they can fix a provincial allowable rate, and they can limit the total amount of natural gas that can be produced within the province. The province also has jurisdiction under the Mining Act to grant leases, transfer them, and even deny them. Provincial environmental impact assessments are triggered when there's an extraction of oil, natural gas, or minerals. These projects undergo a phased environmental impact assessment, and the process begins before well pad construction and includes the following: location of the proposed drill targets, a description of existing environment within the drill target areas, including environmental constraints, location of sensitive areas, and additional proposed exploration activities, details about the construction and operation of the well pads, access roads, and associated infrastructure, details associated with the drilling activities, including details regarding waste management, process and potable water requirements and water sources, material handling and shipping, sewage treatment facilities, any past, current, or future projects or activities in the project area whose effects may interact with those of the project under review, any commercial extraction, pipelines, gas processing, or well decommissioning, and finally any other applicable details or aspects of the project as the project develops. The environmental impact assessment, as Kathy had mentioned, engages public consultation and stakeholder engagement. Its benefits include reviewing activities at an early stage, considering the cumulative impacts of the activities and avoiding operations in sensitive areas. The New Brunswick government has announced new regulations that will take effect this year. These regulations have three purposes. First, they will ensure that any drinking water sources within 200 meters of test sites and 500 meters of drilling operations will undergo baseline measures before they begin. And if there's a change in water properties after testing and operations, the industry has the onus to prove that they were not responsible for this. Secondly, companies will have to disclose the materials and chemicals that they use in the fracking fluid. And finally, companies will have to post security bonds to cover the cost of remediation and damages. These new regulations are a step forward in creating more effective regulations that are specifically directed towards the shale gas industry. However, with much uncertainty in new technologies, the government should aim to create laws and regulations that are clear and concise and attempt to mitigate the potential long-term effects of the industry. The provincial government should also take into account the precautionary principle, which is a principle established in customary international law. And that principle states that when there's threats of serious or irreversible damages, a lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. New Brunswick has the power to license shale gas activities and impose these environmental regulations by way of environmental impact assessments. The province also has chosen to further their jurisdiction over the industry by proposing these new regulations. These new regulations should take into consideration the biophysical and socioeconomic impacts that would arise in the province as a result of fracking. I will now discuss the federal jurisdiction. There are no express federal laws or regulations for shale gas. As noted earlier, it is the province who has exclusive jurisdiction under the Constitution to make laws related to natural resource development and extraction. However, there are still federal laws that indirectly deal with shale gas operations. For example, the Canadian Environmental Protection Act gives the federal government the authority to prevent and manage the risk posed by harmful substances and to assess the environmental impacts of new and existing substances. And it's under this act that the federal government can create a list of chemicals and assess their toxicity to ensure the environment and health of people are protected. The Canadian Environmental Assessment Act gives the federal government jurisdiction over inland fisheries. An environmental assessment would be required for fracking projects that affect fish and their habitat, as there's potential environmental harm resulting from either the taking of fresh water for the operation or the release of chemicals into their habitat by way of wastewater. The Fisheries Act applies to all Canadian fisheries waters, including waters on private property and provincial crown lands. The legislation provides protection over fish habitat and pollution, and deleterious substances are prohibited from being released in a manner that would negatively impact these fish habitats. Under the Species at Risk Act, the federal government has the authority to identify species at risk and their critical habitat. The federal government can step in and protect these species in areas where the provincial government fails to do so. And finally, the Migratory Birds Convention Act prohibits the release of substances that can harm migratory birds in waters used by them. The federal government has the authority to develop regulations to protect these species. The municipal jurisdiction also has a role to play in shale gas development. The jurisdiction of municipalities is limited to powers expressly conferred by statutes, or powers that are fairly implied by the express powers and statutes. The Supreme Court of Canada, in the case of the Queen and Sharma, also identified general welfare powers that municipalities can draw upon. In New Brunswick Municipalities Act, these powers are set out in the first schedule. And the purpose of these general welfare powers is for municipalities to enact bylaws that further the goals of public health and safety. However, these powers are limited, and the true purpose of the bylaw is vulnerable to scrutiny by the courts. In the case of Spraytech and the town of Hudson, the Supreme Court of Canada upheld the validity of a bylaw that restricted the use of pesticides within town limits to specified locations and for enumerated activities. The court found that the law was enacted pursuant to the General Welfare Clause, and furthermore, it respected the principle, the precautionary principle. The Provincial Mining Act of New Brunswick ensures that the holder of a mining lease, a mine operator, or anyone acting on their behalf does not cause actual damage or interference with the use and enjoyment of the land within a municipality without the consent of that municipality. I think it's important to realize that municipalities do have a voice and do have legal power within the shale gas development. When we pursue shale gas development in New Brunswick, the government must also be mindful of their roles and responsibilities with respect to Aboriginal consultation and accommodation. The government has a duty to consult with Aboriginal peoples when an activity has some effect on a proven Aboriginal treaty right or a credible but unproven claim. This legal duty may result in the government to change policies and create plans to accommodate the Aboriginal concerns. The procedural aspects of the duty to consult can be delegated to industry proponents who wish to achieve particular development. However, you cannot delegate the honor of the Crown, and therefore the ultimate responsibility for consultation does rest with the Crown. Industry does not have an express duty to consult, but it's often beneficial for companies to consult with First Nations communities. Creating benefit and impact statements, for example, between these parties often result in more cooperation, and furthermore, government tenures and approvals are often more vulnerable if this consultation does not occur. As New Brunswick expands their natural resource sector to include shale gas, there are many facts both industry and government should consider. First of all, industry and private citizens must be aware of the fractured state of shale gas regulation. There is currently no concise regulatory scheme, and developers must be mindful of federal, provincial, and municipal jurisdiction. It is also more likely that laws and regulations will change as the industry expands. Secondly, government must also consider both the benefits and impacts shale gas development will have on the province. The government should take proactive steps to create a concise and effective regulatory scheme with the goal of mitigating any of these long-term effects. I will now pass the presentation over to John Bird, who will discuss regulatory regimes of other jurisdictions.
In order to assess and determine the direction New Brunswick should head where fracking is concerned, we decided to examine 3 other jurisdictions where fracking is either taking place or is being contemplated. The 3 jurisdictions we chose are Alberta, Nova Scotia, and Pennsylvania. We chose Alberta as it is a Canadian jurisdiction with a well-established regulatory regime where oil and gas is concerned, as well as for the fact that fracking has a 50-year history in the province, where so far over 167,000 wells have been drilled. We chose Nova Scotia as it is in a similar position to New Brunswick. The government of Nova Scotia is currently conducting a review of the impacts associated with fracking, as well as attempting to determine the best practices of the industry. Finally, we chose Pennsylvania as it appears to be the guinea pig for shale gas in the United States. Similarly to Alberta, Pennsylvania has a well-established fracking industry with a firm regulatory regime. I will begin by assessing the practices and case law in Alberta and Pennsylvania, with the caveat that there is very little, before moving on to illustrate how Nova Scotia has handled the issue. In Alberta, there is an estimated 464 trillion cubic feet of natural gas in the Western Canadian Basin. The extraction of this natural gas in Alberta is currently regulated by the Energy Resource Conservation Board. The board is a quasi-judicial agency that was formed by the Government of Alberta. The board's mandate includes approving each step of the development process, arbitrating the concerns and conflicts that arise between companies and landowners, as well as the protection of aquifers. The board has stated that water contamination as a result of fracking is a real issue. Therefore, they have listed that aquifers are to have a cement casing below the level of the aquifer in order to prohibit the upward migration of gas into the water source and damages. The trial judge held that although there was contamination of the well as a result of the pits, it was through an indirect source which could not be traced, and that it could not be held for certain that the activity on the land was the cause of the contamination. Therefore, the judge awarded them only $30,000 in damages. The Court of Appeal upheld the decision of the trial judge on the quantum of damages, and the appeal was dismissed. There is also a statement of claim that was filed in April of 2011 in the case of Jessica Ernst and Encana Corporation. The statement was made in response to contamination of water and the subsequent testing for chemicals used in the fracking process by an independent lab that proved positive. A complaint was made in 2005 by Ms. Ernst to the Energy Resource Conservation Board, which took until 2007 to test her water. The current claim for damages totals over $30 million, and the sources for the claim include the breach of several statutes and regulations, negligence, nuisance, trespass, as well as the breach of our freedom of expression for trying to stifle her complaints. The Marcellus Shale in Pennsylvania is the largest onshore natural gas reserve in the world and contains enough natural gas to sustain the United States for 80 years. The shale gas industry in Pennsylvania is regulated on federal, state, and municipal levels, with a majority of regulation taking place by the Pennsylvania Department of Environmental Protection, as well as the Bureau for Oil and Gas Management. Many of the requirements for developers are as follows. The company must secure drilling rights, apply to the state for a drilling permit, name the source of the water that will be used. This is important as fracking in the Marcellus Shale, due to its depth, requires between 2 and 10 million gallons of fresh water per well. The chemicals used in the process must be listed. However, the amounts are considered proprietary and are therefore not required. Finally, the company must name where the wastewater will be treated, and the treatment plant must have DEP approval. Pennsylvania has an extensive legislative scheme where shale gas extraction is concerned. For example, in the federal realm, there is the Clean Water Act and the Energy Policy Act, among others. And at the state level, acts such as the Oil and Gas Act and Water Resource Planning Act. Currently in Pennsylvania, there are 9 House bills and 2 Senate bills pending approval. As previously mentioned, Pennsylvania does have an extensive list of regulations governing the industry, but these pending bills address many of the significant problems that have arisen from the relatively new industry to the state. For example, House Bill 977 amends oil and gas conservation law to include horizontal drilling by requiring drillers to notify surface rights owners if drilling is occurring below their land. It also sets a requirement to specify the calculation of royalties prior to production and to clarify the minimum 12.5% royalty based on the market value of natural gas. There are also 2 recent cases which indicate current problems with fracking in Pennsylvania. The case of Fiorentino and Cabot Oil and Gas Corporation involved 63 property owners commencing an action against Cabot, stating that Cabot's fracking operations resulted in the release of methane and natural gas into the land and groundwater of the plaintiffs. Strict liability in this case depends on if fracking is considered an abnormally dangerous activity. In Pennsylvania, to prove strict liability, a plaintiff must demonstrate that an activity is so abnormally dangerous or ultra-hazardous that liability should be imposed on the person engaged in the activity for the damages caused by their operations, whether or not they exercise the utmost care to prevent them. This is relevant as New Brunswick also has strict liability. The court said that this question has not yet been determined in Pennsylvania. However, other activities that are closely associated with fracking, such as oil and gas pipelines, have been determined not to be abnormally dangerous activities. The court also stated that future illnesses, emotional distress, punitive damages, and attorney's fees are all potentially recoverable in such instances. In 2011, the court in Barish and Southwestern Energy Production Company ruled that in order to make a claim, the plaintiff must prove that the company was conducting an abnormally dangerous activity, which resulted in harm to the person, land, or chattels. Their analysis, like that in Fiorentino, stated that no Pennsylvania court has ruled that fracking is an abnormally dangerous activity. Further, the court stated that more time was needed in order to allow the record to develop more fully on whether or not fracking is abnormally dangerous. Based on current case law from Alberta and Pennsylvania, we can indicate some potential areas of contention that may arise from fracking. From Alberta, we learned that causation was an issue. Was the water contamination a direct or indirect result of the fracking in the area? The court found that contamination could not be directly related to the fracking in the area. We suggest that the regulation should impose a duty for each company to list the chemicals used in the fracking fluid, and that the landowners have their wells tested on a set basis before fracking occurs in the area and at regular intervals during production. This could potentially alleviate the issue of causation. In Pennsylvania, the court in both cases looked at whether fracking was an abnormally dangerous activity. This is an issue the courts in New Brunswick will potentially be faced with. And as seen in Pennsylvania, various actions would be available to the claimants for damages. So if we had the PowerPoint, I would have had a...
I have an idea,
Okay.
because it's important.
Okay.
We'll put the jurisdictions, and I'll be your secretary.
And
And, yeah. So we have New Brunswick.
Alberta and...
Reporter.
I'll go New Brunswick, Alberta, and Pennsylvania.
Alberta and Pennsylvania.
Yeah.
Okay, so we'll just do check marks,
Sure.
right? Thanks, Wayne.
So what we did is we looked at the proposed regulations that the New Brunswick government is looking at, and then we kind of took the Alberta and Pennsylvania regulatory regimes and kind of mapped them against each other to see what Alberta and Pennsylvania, who have these extensive shale gas regimes, are doing, or what they're planning on doing, and what New Brunswick is planning on doing, and what we think they should all do.
What's the first one?
So reporting of the chemicals in the fluid.
Okay, so report. Chemicals and fluid.
Yeah.
All right.
And this is proposed in New Brunswick. It's not required in Alberta, but it is required in Pennsylvania.
Everyone's gonna have to forgive my writing. Okay, next
We
one.
have amount of chemicals in the fluid, or proportion.
Proportions, okay. Okay,
So it's not proposed in any of them. And again, this is proprietary, and companies state that the amount of chemicals in the fluid is proprietary interest, which is fair enough. However, if a certain amount of chemical is hazardous per X amount of volume of water, then there should be a maximum amount of chemical per volume if it's going to be environmentally hazardous.
so you're proposing a cap.
I can't, yeah. at a
So
certain amount.
not disclosing the proprietary information, but requiring people to have a cap on toxic substances.
Right, I can do that. And then we have baseline water testing,
Okay? Yeah,
and it's proposed in New Brunswick,
okay,
not in Alberta,
not required,
not required, and it is required in Pennsylvania.
okay?
So the first three, these all go to causation. If we can figure out what is in the water before fracking occurs, so if you can say this, and this chemical is in the water before we frack, or these are what chemicals are in the fracking fluid when we're fracking, then when somebody says there is contamination, by baseline water testing and by knowing exactly what chemicals are in the fracking fluid, we can say, hey, fracking probably did cause this because the chemical was not in the water before, it is now.
On the balance of
On the balance of
probabilities.
probabilities.
All right, what's the next one?
Safe disposal of fluid.
Okay.
The chalkboard slides up if you want it.
Does it?
Yeah.
Oh, heaven, okay.
I think, or maybe.
Well, let me finish this
It might just
one.
go down, actually.
Oh. Well, let's finish
So
this
it's,
one.
I would give a check mark to all of them.
Oh, there, okay, so proposed.
Yes.
Okay. Required,
Required.
and required, okay.
And the naming of the water source.
Water source, okay. ID water source. Okay,
So this is not New Brunswick,
not proposed.
not proposed.
Okay,
We're not sure in Alberta,
what's that?
not sure, but we haven't.
So this is the companies saying, this is where we're gonna be taking those trillions of gallons of fresh water from.
Yeah, and it's a requirement in Pennsylvania.
Okay,
And these two are really environmental safeguards. It is so important to have this ultra hazardous waste water properly stored and managed. But, I mean, in Pennsylvania, where I said that it's trillions of gallons of fresh water, I think as New Brunswickers, we all want to know where, it could be just, tens of thousands or hundreds of thousands of gallons of fresh water per well. And I think it's important to know where that water is going to come from, and that, the government should do.
it's a proposed recommendation, right?
Yes.
Oh. Okay. Going with the flow. All right, we'll just stand over here. Losing my job. That's okay. All right. Is there? Okay. Go ahead.
And everybody that fills out the form that wants this, we can give it to you, and the table's on the document.
It's in the presentation.
Yeah.
So, this is an independent body, that's a long one. An independent body to regulate fracking.
Okay. So an independent.
Quasi-judicial body to regulate the safe, responsible, and efficient development of energy resources.
Okay, so independent body. And,
So, not proposed in New Brunswick,
okay,
the Energy Resource Conservation Board in Alberta, so the ERCB,
yeah,
and the DEP in Pennsylvania.
DEP. And to be clear, these are they're independent
What was
of.
it? Judicial, yeah, of the government.
Okay,
And We think we think this body is important because it provides proper management of a resource and expertise and the ability to arbitrate issues of contention that arise. So again, it's a proposal we make. And then requirements for drillers to notify and negotiate with service rights owners if drilling is occurring below their land.
Okay, so requirement for notification property owners. Okay, so what have we got here?
It's proposed in New Brunswick,
Yeah.
and it's, I guess, in both Alberta and Pennsylvania. And we have requirement to specify the calculation of royalties prior to production.
Okay. Okay.
And that's no in New Brunswick,
Okay.
and yes and yes.
Okay.
And then minimum royalty requirements.
Minimum. So this is royalties calculation. And I'm sure everyone at the back can read this, right? No problem. And minimum royalties. Okay, what I got?
No in New Brunswick, and check.
Check.
So these are really important because these ensure that all landowners are treated fairly and equally. If a landowner knows exactly how much they're going to be getting for the percentage.
Mm-hmm.
And then we also have the minimum distance between wells is a requirement.
That was a good one. Yeah.
And you need a minimum distance between wells because it has to do with pressure and it allows for an efficient management and extraction of the resource. So if you have too many wells in a given area, you won't be able to take out as much fluid. So that's not proposed in New Brunswick, but it is in Alberta and Pennsylvania. And then we also came up with two that Alberta and Pennsylvania have not done either. And one is the access to justice opportunities, and the other is posting bonds for remediation and damages. And we need access to justice opportunities. It's to protect property owners going up against big businesses. So if you're a small landowner and you have contamination, we need access to justice because it will inhibit. And I'll talk about that later in the presentation in my conclusions. And the other is posting bonds for remediation and damages. And it ensures that the company goes bankrupt, that remediation will still be able to occur. And that's probably more for the government's sake, and the landowner as well, to ensure that the land is properly taken care of. So I'll continue with Nova Scotia and then give you some of my conclusions. So in Nova Scotia, the provincial government is currently conducting a review of the environmental issues associated with hydraulic fracturing. This was announced in April of 2011, and this review is expected to conclude sometime this year. The aim of the review, as stated on the Nova Scotia Department of Energy website, is to determine how hydraulic fracturing is managed in other jurisdictions and identify the best industry practices. It appears that this review may influence points in the environmental assessment process or set regulations for the industry. It will not have the effect of shutting the door on hydraulic fracturing in Nova Scotia. Part of the review process included an opportunity for input from the public. Public comments have now been put on the website, and periodic updates describe how ministers have been attending conferences in Alberta and Texas on the subject of shale gas exploration. In conclusion, the government of Nova Scotia stated that they would not close the door on shale gas extraction, but would examine other jurisdictions where fracking was taking place to allocate how the industry was managed best. When looking at jurisdictions such as Pennsylvania, where fracking is currently a major industry that is both well-regulated and established, and Alberta, where the oil and gas industry has a firm legislative regime, it is evident that there are still issues where shale gas extraction is concerned. In the states and provinces where the industry is most advanced, it is clear from the Energy Resource Conservation Board reports in Alberta that water contamination is a serious issue, which is confirmed in the minimal case law. In Pennsylvania, it is evident that the established legislative framework intended for regulating industry is not adequate, as is evidenced in the 11 bills currently before the Senate or the House. The courts in Pennsylvania have also refused to rule that fracking is not an abnormally dangerous activity, indicating that more time was needed to determine this issue, meanwhile leaving the door open to potential actions for damages, distress, or illness. Finally, the lack of case law coming from both Pennsylvania and Alberta raises a red flag. The obvious answer is that perhaps fracking is simply just not that dangerous and damaging. Another, perhaps more plausible reason is that there is a lack of access to justice. Litigation is expensive, certainly in the case of many landowners who rely on well water, which at some point may become contaminated because of fracking. The legal community in New Brunswick, as well as the provincial government, should ensure that if fracking is given the green light, that access to justice is not an issue, and that individuals with valid claims should not be hindered by the inability to afford the legal costs. We knew that at the beginning, we said we would only speak on 3 other jurisdictions. However, we would like to take you to one more jurisdiction, an example that all of us here are familiar with. Shale gas development in New Brunswick can be mirrored to the North Atlantic fisheries crisis. The offshore fishery provided many economic benefits to the people of Newfoundland and to the province. The development was rapid and successful from the beginning. There was new technology that allowed for unprecedented catch rates and year-round fishing. However, scientists and those directly impacted, such as the inshore fishermen, argued that the industry should not move forward too quickly. It was unknown what long-term effects these new methods would have on the viability of the cod stock. Within a few short years, the cod stocks were depleted and there was a moratorium on the fishery, causing devastation throughout the entire province. Politics and economics pushed the resource to destruction. If the science and the long-term effects are not considered in shale gas development, politics and economics will lead New Brunswick down a similar path. I would now like to pass the presentation on to my colleague Wayne Solomon, who will discuss our conclusions and recommendations.
Hello, as you said, I'm Wayne Solomon. As New Brunswick explores the potential of expanding the shale gas industry in the province, they must move forward with caution. From a thorough assessment of the scientific process, the current regulatory scheme in New Brunswick, and case studies from other jurisdictions lead us to propose consolidated legislation for shale gas exploration and development, an independent quasi-judicial body to monitor the regulations of the industry, a regulated scheme to provide access to justice for property owners, either by covering legal costs through a security bond posted by developers or covering legal costs through a percentage of government royalties. Required notice and negotiations to property owners before the developers stake a claim to explore and develop. An independent body to assist landowners in negotiations of land use and royalty payments. A regulated royalty payment schedule establishing a minimum amount to be paid to property owners for surface rights access. Regulations ensuring developers to list chemicals used in the process, disclose locations where fresh water will be taken, and ensure the water will be treated at an approved site. Lastly, we recommend creating a clear plan for disposal of fracking water other than the reservoir containers. In conclusion, fracking in New Brunswick potentially brings great rewards: energy, employment, and economic stimulation, all things we want and need. However, with this potential for great reward comes great potential risk. While New Brunswick appears to be moving forward quickly to develop this industry and gain a competitive advantage, the environment and legal concerns are great. The drilling and extraction process has the potential for great environmental damage if done improperly or carelessly. The regulatory framework is in its infancy and is not cohesive or certain. While the Provincial Oil and Gas Act and Mining Act are key legislation for shale gas extraction, other legislation may be introduced with oversight by other provincial departments, along with the various federal acts and municipal bylaws. Shale gas in New Brunswick provides us with a consistent theme of caution. Environmental concerns and potential for problems are high, and if mismanaged, could lead to lawsuits and expensive reclamation. The regulatory framework for shale gas is underdeveloped. The rights of municipalities seem clear based on the limited case law, but need to be carefully considered, as do the Aboriginal rights. So we would urge New Brunswick to proceed with caution. Learn from other jurisdictions, such as Alberta and Pennsylvania. Don't proceed carelessly, leaving future generations to pay for mistakes. Leave a legacy of well-developed and thought-out regulations, an environmentally and economically sound industry, and employment for future generations. Thank you. We would be pleased to take questions, and I'm not sure where that list is, but if it eventually can make its way up here with everybody signing, I would be glad to get you a copy of our presentation. Thanks again on behalf of all of us and all those that were involved in doing the research. It wasn't just the 4 of us.
Just quickly to mention those that were involved in the writing of this paper. I know we are taking all the glory, but these are all University of New Brunswick law students. Nathan Lapper, Amy Thomas, Rebecca Butler, Wayne Solomon, Sarah Anning, Riley Desjardins, Kathy Lewis, Jenny Pick, and what else? Am I missing anyone? No, okay. Yeah, and it's on the paper too.
Before we do start fielding questions, and I do hope there are some questions, I'm going to do a typical lawyer thing. The information provided today was not legal opinion, it was legal information. And as such, please do take this opportunity because they have learned this subject inside and out. So they're happy to answer your questions and provide information on what they've learned. That said, if they can't answer a question, they're going to look at me and panic and I'm going to say time out. Or I'll help you answer the question. But please, any questions? Yes. I'm sorry.
I don't have a question, but I have a comment. You may have found it out anyway and just not put it in your paper, but 3 weeks ago, Pennsylvania actually had a ruling that doctors do not have to tell people which chemical they are becoming sick from. Even though it's a fracking chemical, it was handed down from the governor's office that, in fact, they're not allowed to. It's not that they don't have to, it's that doctors are not allowed to tell people which chemical is making them sick.
Was it the claims of proprietary interest that John was talking about?
It didn't specify. It just said that doctors are not allowed to tell people which chemical they're getting sick from. And that was about 3 weeks ago, maybe 4, that I heard it when I was away for
I'm just wondering where the sheet is. Haven't seen it.
The sheet, it's coming around. Question?
Yes, in terms of native water rights, just recently I've had the opportunity to read many decisions from both sides of the borders. How much influence can the native response be in this matter?
How much influence can the native response be? Is that the question?
That's correct, yes. And that's,
Yeah, okay.
Go ahead.
No, but I'm going to give you the first guess. Well, we know about the Crown duty to consult, which is what Rebecca was talking about. And that duty is not, the honor of the Crown cannot be delegated. That said, it is important for organizations, should they pursue this, to engage the First Nations community as early as possible. What we do know is that should an environmental assessment be triggered by fracking, which we think it would, there is a portion of the process where there's Aboriginal and First Nation consultation in an environmental assessment context. The value and the importance of engaging First Nations groups and listening not only to the history, but also to the current experience of the First Nations group. So when we were in class, we studied a couple cases that had to do with First Nations consultations in relation to things like bridges, pipelines. But this would be a similar sort of thing. So the First Nations opportunity to consult, or to be consulted, is enshrined in Canadian case law. What is not clear is what constitutes that duty. Case law says that it has to be meaningful consultation, which means requiring the proponent and the Crown to engage the First Nations on the First Nations terms, and each First Nations culture would be presumably different, and so the engagement for the various First Nations would be accommodated and addressed to the needs of that particular First Nations. What we also know from case law, and I know because you studied it and you loved it, was that the duty to consult, as I mentioned, must be meaningful, but there's a great amount of uncertainty as to what meaningful means. Furthermore, we know that there's a requirement to accommodate First Nations concern. And what we don't know is what does it mean to accommodate First Nations concerns. So we have at least one case law out of the Supreme Court of Canada saying that the parties do not have to come to an agreement, but the Crown and the proponent are under a positive obligation to consult, as I said, meaningfully, to take into consideration concerns and accommodate those concerns in an appropriate way. That's a long way of saying it's vague.
Because what I've seen from what the judgments that I've read, a lot of references, what was made to treaty rights,
Yes, right,
first ownership,
yes.
and whereas like the St. John River aquifer, I mean, it's huge, and from what I'm getting is that there is going to be contesting coming from the native communities,
Entirely.
exercising the treaty rights and in attempting to prevent the exploration. Because again, you said an interesting point of what constitutes a great risk, but the aquifer is so large that the side effects. I mean, I just want to think, we can talk about, litigations and monies being paid out, but, there's a thing going to be that, whoever develops this will eventually have to pay everybody in New Brunswick what the market value is at the given time that the problem occurs. We've seen so many times, even legislation, being a captain, being under the influence, piloting your boat, there's hundreds of regulations but the Exxon Valdez, captain all liquored up and puts his boat aground, and we're still feeling the aftermath. So this is a serious matter that we're dealing with.
I think you're raising, sorry.
No,
I think you're raising an important point, which is sort of mitigation after the fact in order to mitigate that loss is a huge problem in assessing remedies in Canadian jurisprudence. And it's so important that we educate ourselves and that property owners and Aboriginal people who may have treaty rights over that land understand and are able to assert their rights before development occurs. Unfortunately, there isn't necessarily, without these regulations being put in place, it's a lot more difficult to assert rights, to understand what's going on, to understand that you as a landowner don't actually have rights to what's going on under the surface in your land. And there isn't a lot out there of opportunities for people to come forward, so it's kind of anyone who can do it on their own and make some noise about it is important.
If I could just follow that up, because there's a word that you used and a word that you used, and you said may have rights. The First Nations may have rights. So we do know from case law that the duty to consult is triggered whenever there is an actual treaty or a potential Aboriginal right. That is relatively recent. It used to be that it was just if there was a treaty or a clear Aboriginal right invoked this duty to consult. We now know that it's when there's a potential First Nations claim that this duty to consult is triggered. And we also know that treaties from, help me out, you guys were in my class, like 18 whatever, do you remember the case I'm talking about?
Actually, it's when the Constitution was passed, all existing treaties at that time are now enshrined in the Constitution. And
Yeah.
in order to, but the thing is, we don't necessarily know what all of those treaties were at the time that the Constitution was enshrined. So you may have a constitutional right to that land, but we don't know.
No, but what I'm referring to, and I am the worst with names. I remember everything about a case, forget the name, but it's a case where it was a treaty from like 1812, it was pre-Constitution, and it went to the courts because there was a question as to whether the treaty required additional interpretation in current times. So the wording of the case from 1812 had to then be interpreted in the context of 2010, 2011.
Are you talking about
Was that Delaware's? No.
Well, that's kind of like the issue with pretty much all, like you kind of summed it up with all treaties, like it's how do we translate? And I don't think that there has really been a case that's dealt with water rights yet. We've had lots of cases that have dealt with access to resources, like trees, cutting down trees, logging, fishing, everything like that. But as far as protecting water, there really hasn't been one, and it's hard to say like how that would be interpreted in the modern context, because I don't think it's something that was ever contemplated at the time.
Who would have thought we'd be doing this?
Yeah.
But it seems to me that the Aboriginal rights are sorted in kind of two categories. One has to do with the activities, hunting and fishing and so on. So what are the impacts on the hunting and fishing? And the other one having to do with access to land and land use, and how does this activity impact that? Okay. Any other questions?
Just to that point, and I'm a layman, so bear with me. Last I heard, and I may have misunderstood, but the last I heard, there wasn't much in the way of a royalty regime for individual landowners proposed in New Brunswick. So I wonder if you could clarify your proposal up here for me. You're proposing a change in the law, or maybe just clarify that for me.
What we did is we looked at, I'll get my chart out. We looked at, in Pennsylvania, it's 12.5% royalty for oil and gas owners.
But
And it's
property rights in the states are different, though.
Yes, they are.
Yes, they are, but in Alberta, it's 5% royalty. And so and that's not a proposal in New Brunswick. And so we're thinking that it should be,
Okay.
and it should just,
But is that a comprehensive change in the law, or how, did you give any thought to how that would work?
I don't know if it would constitute a comprehensive change in the law, would it? Or would just,
What do you mean by comprehensive change in the law, though?
There isn't, and then there will be.
Oh, yeah, okay. Let me put it this way. No, we don't have the regulations right now. What the students were doing was sort of saying, okay, this is what the government's proposing to do.
Right.
How does it match up with other jurisdictions?
Sure.
What can we see as other problems in the other areas? And what I'm hearing they found was other jurisdictions had a problem with causation, and they had problems with access to justice. So those were the drivers. The royalty issue is simply clarification, I would think, because right now, property owners don't
Yeah.
have any certainty or knowledge of minimum calculations of the royalties that would be applicable. So
Would it be a contractual obligation?
well, remember, they have to get land access agreements, right? So part of the land access agreements, what would be legislated imposed would be part of the royalties.
right, it's because we want all landowners to be treated fairly. So you don't want one landowner maybe getting 7% and another getting 3%. It's a mechanism so people aren't taken advantage of, I think.
And again, you looked at what was working in other jurisdictions. And we saw this as a positive. Anything that puts dollars in the pockets of landowners was a positive, and protected the interests of property owners was a positive. Right? Yes.
First of all, I think the case you were thinking of earlier was Delganook.
No, it was,
No.
I have a picture in my head, like a map, and I can see it. It was this road that was Wood Buffalo.
Oh,
Wood
and-
Buffalo.
Wood Buffalo Park.
and-
Yeah, that was the case I was thinking of. I'm so sorry.
That's okay. No, that's fine. I wanted to, first of all, congratulate the students, those who were there and those who were behind the writing. I thought you did a really great job of looking at the regulatory regime and doing a comparative analysis. As a private practitioner, I'd also like to chip in a couple of possible insights about potential problems that access to mortgages. And the issue, as I understand it, with homeowners insurance, of course, this kind of makes sense. If anybody knows how to gauge risk, it's insurance companies.